Okay, I've just been informed that some students are writing a test for English for academic purposes. I will definitely take it up with the HOD that they should not be setting tests for students during other lecturers' class time. But on the other hand, with the shortage of test venues on campus, I suppose it is difficult to find, and English for academic purposes is obviously a very large group of students. So I do have a measure of sympathy. They probably couldn't find another time or another venue. So I won't shout at them too much. But in any event, I am recording the class, and the recording will be shared on YouTube as always. That works very well. So for the students that cannot attend the class, they will just have to download a recording and listen to the recording. Okay, first of all, your test results. I don't know if you saw. Test 1 results have been uploaded on the kiosk. If you wrote and there's no mark for you, please contact me so that I can find out what went wrong there. But all the marks should be there. The actual test scripts are available on the counter just outside my office. So on campus, on upper campus in the office building, office block room 313 is where my office is. So you can go and collect your test scripts from there. Students that wrote out of town, students in the regions, the test scripts have been returned to the student support officer, who will return them to the various regional centers. So you will also be able to collect your scripts from there in due course. I must say, honestly, I am so pleased with you. I am honestly so pleased with you. I think rough estimate, I didn't do a precise calculation, but I think rough estimate, the class average was 60% and above, around 60%. The results were lovely. And I could absolutely see from the test scripts who attended the class or listened to the lectures, to the recordings with care, with great care. It's interesting. YouTube gives me all sorts of analytics. I can see how many people have downloaded my recordings. I can also see how long people spent watching the recording. And I was a bit shocked to see there were some people that downloaded a recording but spent 7 minutes listening to it. That doesn't make sense because all the recordings are roughly an hour long. Listening to it for just 7 minutes, you essentially just going to listen to my pre-lecture speech. But the students that had attended class, not just logged in, but actually focused, attended class, same faces. I see the same faces over and over again. I love seeing your faces. Makes me feel good to see you in class. So I know who my regular class attenders are. Students that attended class, students that listened to me and worked through the worksheet as I had recommended. I told you every single question in the test, apart from multiple choice, was taken from the worksheet. So if you'd work through the worksheet and continue with the worksheets, people, they are on e-learning, all of them, even for the new unit, the units from 13 onwards, right to the end. The exam is also, won't say going to come entirely from the worksheet, but I will definitely make use of the worksheets when I set your exam. So don't only wait until it's time to prepare. Make a little bit of time on a daily basis or a weekly basis to go through the questions pertaining to whatever I had covered in the lecture today. It shows. There's just a question here about company law that was cancelled that you need to take up with the faculty officer. I did not do that. I'm not in a position to randomly cancel students' registrations. Take it up with the faculty officer, Miss Yvonne Shipanga, but it could be because you had not met the prerequisite, because you had not passed introduction to law. In that instance, I can unfortunately not assist you. I cannot waive the prerequisite. Prerequisite is there for a reason. You'll see today, Unit 13 that we're doing, representation of a company. I'm going to be relying heavily on what you learned. I'm going to be relying heavily on what you learned in Introduction to Law, in the unit on the law of agency. There is a reason why Introduction to Law is a prerequisite for company law. So moving on then, as I say, I got some excellent results for the test. I just want to reiterate that. Nice distinctions. Also got some very low marks. Students who I had one student that got 4%. Now shame, really. 4% for that test. That student obviously went in and tried to write the test without any preparation whatsoever. But the majority of you, thank you so much. That's all I want. I put in as much effort as I can for my students. I care deeply for my students. And the only reward I want is to see those marks. But moving on then, Unit 13, representation of a company. You will recall that when we did partnerships, we also had on representation of partnerships, contractual liability. If I'm talking about representation of a partnership, representation of a company, I'm talking about when is a company bound to a contract entered into on its behalf. That bit we're actually only going to get to on Thursday. Going to do the first half of Unit 30 tonight. Just give me a moment. Let me upload my slides quickly. Okay, just give me a thumbs up. Can you see the screen with the slides? Thank you, Sydney. Thank you, Alexandra. Okay, So, representation of the company. Just remember, once again, usual protocol. While I'm teaching, I'm focusing on the screen that has the slides, not on my Teams window. If you have any questions, please feel free to interrupt me. Just speak up, just call out, and I'll give you the opportunity to speak. Feel free to interrupt me, or alternatively, post your questions in the chat box. So, what we're going to look at this evening is the first half of the unit. So tonight is not going to be a very long class. It's only literally 2 pages of the notes. The concept of pre-incorporation contracts. I must just warn you, Unit 13 is very important. It will definitely be assessed. So full focus, please. Pre-incorporation contracts. Learning objectives there, always go back to them, always look at them, see if you can actually answer the questions that are posed there. So let's go back. The slide, unfortunately, refers to business law. It says revision business law. I haven't updated my slides. The units were the unit in law of agency and business law, and the unit in introduction to law is exactly the same. So the slide is still applicable. We're not revising business law, we're revising introduction to law for accountants. So law of agency, something that we come across very regularly, like almost on a daily basis. What is the law of agency? What is agency about? Agency takes place when an authorized person, a person with the necessary authority, concludes a contract on behalf of another person, known as the principal, in such a manner that the rights and obligations in terms of that contract accrue to the principal. So the principal and not the agent becomes bound to the contract. In order for this to happen, in order for the principal to become bound to the contract, firstly, the principal must exist. Cannot represent a non-existent principal. Secondly, the agent representing this principal must have authority. And thirdly, the third party must be aware, must be informed. Agent must inform the third party that he or she is acting as an agent and not in his or her personal capacity. Remember those 3 requirements because they are relevant for what we're going to learn tonight. If the agent was not authorized, if there was no authority, but the principal is subsequently satisfied, is happy, likes the contract, and wants to be bound. So without authority, the principal is not bound. But if they wish to become bound, they can ratify the contract. Remember the spelling here. It's ratification, not rectification or rectification. There's no C in it. Ratification, where principal retrospectively, working backwards, or gives authority, accepts the contract. If that happens, the legal effect will be that the principal will become bound as if the contract was authorized from the onset, from the start. important requirement for agency is the person on whose behalf the purported agent professed to be acting must have been in existence at the time of the contract. So if the principal wasn't in existence at the time of the contract and only comes into existence at a later stage, they cannot ratify this contract. Once again, that is relevant. Remember this, understand this. So tonight we are looking at pre-incorporation contracts. So the first thing I want you to think about, quickly, somebody can answer here. When is a company born? When does a company come into existence? Somebody quickly tell me.
When it is registered.
Mr. Mapenzi, yes, when it is registered. By the way, Mr. Mapenzi, your company law, your test results were lovely. Well done. Very proud of you. Yes, a company only comes into existence when it is registered. Before that, it isn't. Company doesn't exist. Going back, the principle must exist. So in terms of the law of agency, an agent cannot represent a company before it has been registered because it doesn't exist yet. But now we need to think about the realities of business. If we look again, I said pre-incorporation contracts. Company is registered if a company is incorporated. Same thing. Registration, incorporation is the same thing. So a pre-incorporation contract is a contract entered into on behalf of a company before it is registered. Why would a company want to do that? Why would this be necessary? For practical reasons. Let's say Ilse, Maria, and Selma want to start a shoe shop. And they want to register a company and sell designer shoes. Now, they go to Marua Mall and they see there are premises available. Perfect shop for Ilse, Maria, and Selma's shoe shop. Let's call it, they're going to name their company IMS, IMS Pty Limited. IMS Pty Limited doesn't exist yet, but there's perfect premises. To register the company is going to take time. But they want to enter into a lease agreement in the meantime to make sure they get these premises, that somebody else doesn't move in there. Company isn't registered. In terms of principles of agency, neither of them, nobody can enter into this lease agreement on behalf of this company. But this company doesn't, because it doesn't exist. So what now? There's a practical, and they don't want to take this lease agreement. Maria doesn't want to enter into this lease agreement in her personal name, because then if the company doesn't make money, she's held personally liable for payment of the rent. She would prefer to avoid that. So what now? There's a practical reason why under certain circumstances, companies would want to enter into a contract, or the promoters, call them the promoters. The promoters is a word that we use for the people that are going to register the company, the first shareholders. There's a practical reason why promoters would sometimes want to enter into a company or into a contract that will bind a company that will be registered, that will come into existence at a later stage. In terms of common law of agency, it cannot be done. We have a problem. But the clever people that wrote our laws are aware of this. They realize that there is a practical need sometimes to do something like this. So they stepped in, and in the Companies Act, they included a provision which relates to pre-incorporation contracts. It's quite lengthy. There it is. I'll read it to you. It says, a company can ratify or adopt as its own, after its incorporation, any written contract entered into by someone purporting to act as the company's agent or trustee before its incorporation, as if it had been duly incorporated at the time when the contract was made, and the contract had been made without its authority. Long sentence there. I won't ever expect of you to write that long sentence down. Essentially, this provides the common law rules of agency still exist when it comes to individuals. So if Mr. Hayter wants to represent somebody, and that principle is a human being, that principle must exist. But for the purpose of companies, due to the practical business demands, and also closed corporations that we'll look at the end of the semester, for the purpose of companies, the Companies Act has made a statutory exception to these general principles of agency, allowing promoters to enter into a contract for this non-existent company. And then once this company comes into existence, this company can ratify this contract as if when the contract was entered into, the company existed, but there was no authority. Are you with me? Do you understand? Give me a quick thumbs up if you're still with me. Okay, great. Now, in order for this to happen, in order for the company to become bound to this pre-incorporation contract after it has been registered, there are certain requirements that have to be met, which are laid down in the Companies Act. If these requirements are not met, the company will not become bound. Contract must be in writing. It must be entered into by a person who professed to act as agent or trustee of a company not yet formed. Upon registration, one of the memorandum of the company must contain as one of its objects the ratification or adoption of the contract, so it must be mentioned in the founding documents. 2 copies of this contract, one which must be notarially certified, must be lodged with the registrar of companies upon registration. The company must be entitled to commence business, so it must be registered, and a certificate allowing it to commence business must have been issued. And then the company must actually ratify or adopt this contract after its incorporation. So some of these requirements are fairly self-explanatory. I'm not going to elaborate on them. It must be in writing. Don't need to explain to you what that means. Mentioning it in the memorandum of the company and submitting 2 copies of the contract, and the contract must be registered and entitled to commence business. That's self-explanatory. I don't need to elaborate on that. What I am going to elaborate on is firstly this requirement that the contract must be entered into by a person who professed to act as agent of or trustee of a company not yet to be formed. And I will also elaborate on that one, that the company must actually ratify or adopt the contract after adoption. The company must be represented by a person who professed to act as agent or trustee of a company not yet formed. That means that when they enter into this contract, the person representing the company, let's say it is Selma who is entering into this contract with Marua Mall to rent these premises. When she enters into this contract with the owners of Marua Mall, I think it's Capricorn Properties, she must tell them that I am representing a company that has not yet been registered. And in this written contract, remember the contract must be in writing. In this written contract, it will state Selma Indongo acting on behalf of a company still to be registered. It must be made clear. Now, what I found in the past is that this bit, acting as an agent or trustee of a company, confuses students. So I'll give them a case study and I'll say, Selma entered into this contract. And they'll say, no, it's not binding because Selma is not an agent or Selma is not a trustee. That's wrong. They've got it all. You've got it all wrong there. The description of the person, the Company Act refers to an agent or trustee. I'm not talking here about a professional agent or a professional trustee. It's just the Company Act's wording to refer to the person representing the company. In most instances, it is the promoter, or it can be anybody else. It can be any person, as long as that person is authorized to represent this future company. The important bit here is not the agent or trustee bit. The name, the role of the person is irrelevant. The important bit is who profess to act. The fact that this representative must have made it clear, that they are representing a company which has not yet been registered and that they are not acting in their personal capacity. This relates back to the common law provision that an agent must inform the third party that he or she is acting as an agent and not in his personal capacity. It mirrors the common law requirement. Why this is important, for practical terms we will get to. in a while. The other requirement is this one, that the company must ratify or adopt the contract after its incorporation. The company must ratify the contract. Now, if you were in my class last semester, you will remember that when we spoke about ratification, I told you that you must never say, never ever write that so-and-so must ratify the contract. And I will penalize you if you say that, right, they must ratify the contract. Because ratification is optional. You can never say somebody must ratify something. So am I now changing my mind? Did I lie to you, or am I lying to you now if I'm saying the company must ratify the contract? I didn't lie to you at the time. Mike's muted, please. I didn't lie to you at the time. I'm not lying to you now. I will never lie to you. What this means is the company still has the choice. That choice, whether to ratify or not, still exists. But in order for the company to become bound, they must have ratified it. If they have not ratified it, the contract will lapse. It falls away, and nobody incurs any liability. So let's say Selma entered into a contract on behalf of IMS Pty Limited, company still to be registered, for these premises in Marua Mall. But by the time the company is registered a month or so later, they realize that actually Marua Mall is not the ideal place for their shoe shop. And they would actually like to have it in Vernhill because it's walking distance from the NUST campus. And there is actually a nice property available in Vernhill. So they don't want to be bound to this contract in terms of with Marua Mall anymore. How do they get out of this contract? IMS Pty Limited is now registered, but it does not ratify the contract. And because it hasn't ratified the contract will lapse. It falls away. Contract that is lapsed isn't a contract anymore. It falls away. But now, if you're clever and smart, which you all are, think for a moment. For a moment, put yourself in the shoes of Capricorn Properties. You had a lease agreement with this company. Now the company doesn't ratify the contract. The contract lapses. You're stuck without a tenant. Are you going to be happy? Think business, not law. Think business. Mr. Mapenzi, you own a building and somebody has told you that they're going to rent premises in this building as from November. And November arrives and suddenly you find out, but actually, no, they're not going to rent anymore. Are you going to be happy? Because in the meantime, you've turned away some other people.
No, it's not good for business.
It's not good for business. So we're coming full circle to this provision that the company must be informed. Remember, these are business transactions. You're doing business with companies that have their own advisors, etc., etc. They must be informed so that they can make the calculated decision. Are they going to enter into this contract or not? Like, you don't want them to enter into a contract and then find out 2 months later that, oh, but actually the contract has fallen away. So these two requirements complement each other, also for practical business purposes. So what can the company do when they enter into this contract? If IMS Pty Limited has now contacted Mr. Mapenzi to rent offices, rent premises in his building, what can Mr. Mapenzi do to look after his own rights? The law provides for this. In general terms, once the contract has been registered, it comes into existence, and it is been, after the company has been registered and has been adopted or ratified by the company, it comes into existence and it is binding between the company and the other party. As is the normal principle in the law of agency, the agent or trustee incurs no liability unless it has been expressly, let's put this in here for future reference, expressly agreed upon. So what Mr. Mapenzi is going to do as a smart businessman, when Ms. Indongo comes to him and says, I want to rent these premises in your building, but I'm representing a company that must still be registered. He's going to say, okay, I'm prepared to enter into a lease agreement with you, but we will include in the agreement that in the event of the company not being registered or not ratifying the contract, that the promoters, Ilse, Maria, and Selma, will be personally liable in terms of this contract. Once again, this is a business transaction. They can then decide, do they want to take this risk or not? It's not really a risk as long as they don't subsequently change their minds. And it also protects Mr. Mapenzi, because then if the company doesn't ratify it, he's not stuck without a tenant. He can then turn around and hold the promoters liable in terms of the lease agreement. Short, sweet, and clear. Did that make sense to everybody?
Yes, ma'am.
Okay. Not complicated at all, as long as you understand that provision about what it means, that sentence, that requirement says that the agent or trustee must profess to act on behalf of a company not yet registered. And as long as you remember, this is actually the crux. If the company does not ratify the contract will lapse unless personal liability has been expressly agreed upon. But if it's not stated in the contract, it lapses, it falls away, no claim from anybody. Okay, short and sweet. Shikupe, You've got a question? Your hand is raised.
Yes, ma'am. I wanted to find out what I don't know if it's the second last requirement that the company must commence. Are we referring to the contract or the registration?
No,
In terms of
that is part of the registration process.
mm-hmm.
It's actually just an indication that the company has now been registered.
Okay.
Once the registrar of companies has registered the company, they issue a document called a certificate to commence business, which
Mm-hmm.
allows a company to start trading. So that is part of the registration. It's just a way of saying that the registration process of the company must have been completed.
Okay. What happens then now if the registration never gets completed?
If the company is never registered,
mm-hmm.
the same would happen as if the company didn't ratify or adopt the contract. The contract lapses.
Okay. I see.
So if our three ladies, who were they? Now I've forgotten their names. Ilza, Maria, and Selma, after they've entered into this contract, they decide, well, actually, they don't want to start the shoe shop anymore. They're not going to register the company.
Mm-hmm.
Then the company will lapse and there will be no liability unless the company had expressly the contract had expressly provided for this. Is that clear?
Yes, ma'am.
Okay. Any further questions? Ms. Navonga?
Ma'am?
Yes.
Please, I cannot find Unit 12. Is it on e-learning?
Unit 12 is on e-learning. All the units are on e-learning.
I was looking for it, but then I'm only getting Unit 13 and 14.
I'll go and have a look again, but I'm pretty sure it is there.
Okay.
Mushigwera, you also had your hand up?
Ma'am, I think I answered my own question. I wanted to ask, is there a certain period for the company to ratify the contract? But then I think it should be within a reasonable time.
Absolutely. Everything must happen. This is law. Everything must happen within a reasonable time. 100%.
Yes, thank you, ma'am.
Okay, further questions? No further questions. Then I will see you on Thursday evening. Bye.
Thank you,
Bye.
ma'am. Bye-bye.
Aye. No, ma'am.
Yes.
Ma'am, before you leave, I just wanted to know for those of us that are not registered or that whose